Friday is For All Service Day. This is where you can get free legal information on all sorts of things. Talk to a lawyer one-on-one. We know you have questions for lawyers out there. That's why we have Mike Wells from Wells Law here with us today. He is one of those lawyers taking part in For All Service Day. He does estate planning, and he can talk to you about all of that as well. We want you to be able to get your questions to Mike about wills and things of that nature. So this is how you get your question to him. The number is 336-379-5775. Remember, this is a text only, so please don't call, and we will get your questions to Mike directly. All right, first and foremost, let's kind of give everyone a big picture about what For All Service Day is.
Well, For All was started, and the name, don't let the name throw you off, but it's really to provide free legal services for our citizens across the state. So many people do not have access to attorneys. So this project started with the hopes that we would have good information for people where they could call to an attorney, not cost them anything, and many times they would head off a problem that otherwise would be a problem, but for some good legal advice or some legal direction. A lot of times the best legal problems are the ones you don't have, and so these calls have proven to be very effective for so many citizens, literally 100,000 over the time that this program has been going on. So we hope we're doing a lot of good, and we hope to do even more.
So there are dozens and dozens of lawyers who will be manning the phone on Friday. So whether you have a crime issue, a divorce issue, a custody issue, an estate planning issue, whatever it happens to be that you need a lawyer to give you information on, they will get you to the right person. So Mike, of course, is going to be answering the calls when it comes to estate planning, but we're going to go through some of those questions that you might have so you can get those answers now. For instance, let's talk about wills. Like, what happens if someone just simply doesn't have one?
If you don't have a will, the state of North Carolina writes one for you because your property has to go someplace. And the statutes provide a pretty arbitrary decision about who gets what. For example, if you are married and you have children, most people are going to leave everything to their surviving spouse. But if you do not have a will, your property will be divided among your surviving spouse and your children. So one of the main reasons to have a will is it's not going to go the way you think it wants to go. So the law has to make some arbitrary decisions so that your property does go someplace. So if you want it to go where you want it to go, it really is important that a simple will, which is very affordable, is something that you should have done.
I think most people would think, yes, if I died, it would just go to my spouse, and that is not the way that it goes. So it's good for people to hear that loud and clear. All right, let's talk about the general power of attorney. I know there's a health power of attorney, there's a financial power of attorney. Why do we need these things?
Well, first of all, let's not get confused with the words. These lawyers use some clunky words sometimes, and financial or durable power of attorney is the phrase. Basically, it says that somebody can handle your financial stuff. If you do not have one, the law does not appoint someone. Your spouse is not authorized independently to be able to sign tax returns and any number of other things. So particularly as you get sick and infirm, if you've had some stroke, for example, or something like that, somebody's got to be in charge of your financial affairs. So a financial power of attorney allows you to do that, and also to provide kind of a pecking order. Many folks will provide their spouse or their significant other or their parent, after which they may name another loved one or somebody in whom they have confidence. So if you don't have one, the law doesn't write one for you, and you're going to be dealing with a very expensive mess if you do not have one in place.
And so again, I think conventional wisdom would just tell you that your spouse is going to take care of it, but again, they cannot sign your name to documents and things of that nature, especially if you guys have separate bank accounts. A lot of couples have that. They would not be able to have access to that without that financial power of attorney.
Correct, and that creates all kinds of havoc because, of course, the bankers and others who are in control of financial assets are going to be very careful before they allow someone access to financial records, financial information, if you don't have some legal authority to have that access.
So we have a question that deals with power of attorney. This person says, if a durable power of attorney has been signed by all parties, but not filed at the clerk's office, is the POA active and usable?
Yes, a financial power of attorney, or durable power of attorney as it's often called, does not have to be recorded under North Carolina law to be fully effective and legal. Now, it is recommended that you do file it at the courthouse, which is a nominal fee to do that. But yes, it is helpful, because when banks and all go to look, they want to make sure that there's some record of it. But under North Carolina law, a financial power of attorney does not have to be recorded at the courthouse to be legally effective.
You just have to have that piece of paper in your hand and be able to present it to the bank or whoever needs it?
You have to have the original of it,
Okay.
yes, for sure.
All right, we're going to take a quick break. We've got a bunch of your text questions here. We're going to also answer some questions about healthcare power of attorney when we come back. You can text us in the meantime. We'll be back in just a few minutes.